Good morning. This is Rich Sierra, President of Florida Small Business Legal Center. This is episode number 60th of Business SOS podcast. We're very excited that you're listening to us this morning or afternoon or evening, whenever you listen to the show. We're excited that we're continue moving forward to my goal to do my first 100 episode. That obviously we have 40 more to go, so one at a time. And I hope that you enjoy the content that we're providing to you that will help you navigate the legal challenges that you will face in your business journey. And every business, no matter whether it's small or large, will face legal challenges because we're dealing with people and sometimes things go wrong. But my goal is to help you, give you some tools that you take in each and every show to help you say, you know what, give you that nugget, say, you know what, I remember listening to this podcast with Rich Sierra, and then I learned something new today that I could actually take with me for my business. So I will start the show. If you have a legal question, anything you'd like me to cover in the show, you can send me an email at rich@richsierra.com. And if I select your question, and then I'll go over that with the show, I'll send you a free copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them, which is available on Amazon, Barnes & Noble. You can ask for it in your local bookstores. A common question that I receive, I do quite a bit of litigation throughout my career. This is now, I'm going on my 20th year as a business litigator in South Florida. And a common question that I receive is like, Rich, why are lawsuits so expensive? And I've talked about that before throughout in some episodes. And I think I dedicated an episode last year on business litigation and budgeting for litigation as well. So today I want to talk a little bit about that as well and really address the subject of why lawsuits are expensive. But before I do that, I want to tell you about some programs that I utilize in my office that are available for those who are interested in financing their legal services. As you probably know as a business owner, that there are a number of pockets or sources of financing if you have a legal dispute. It could be your own cash that you have in your operations account or your business account. It could be credit cards, that you utilize to pay legal services, or perhaps if there's an insurance company that agrees to take on the case, depending on the type of matter that you are being sued for, then you have the insurance company that helps you decide to take on the case because you have coverage, and then in that case, they take over the representation of your case. And of course, last but not least, which is the least desirable one, is you representing yourself in a lawsuit, and we've gone over that before, and which is not recommended. But also, if you own a business entity in Florida, anything above small claims, you have to have legal representation. So that's something that, you have to know that if you get sued and if anything over small claims, you need to get a lawyer. You cannot do it yourself. Unfortunately, some clients have attempted to do that, and then they have their pleading stricken, and then we have to start all over again or undo what it was done. I went over that before as well in a prior episodes. But first, I want to tell you about two programs that I'm very proud that I have available to my office, to my clients. One is Sunbit Financing, SUNBIT Financing. And these are companies that are not related to my company. They're simply that they give me the opportunity to offer those to the clients who are interested. And then if they qualify based on their criteria, they work that out directly with the company. We don't participate in any way, shape, or form. It's simply another option. It is not publicized that much because these are companies that focus on niche type of businesses, and we're fortunate to be one of those. So Sunbit Financing is basically, this one is credit-based, and you basically you can do a pre-qualification without any type of, does not affect your credit. If you decide you want to find out how much you qualify for. They have a certain limit, how much they actually lend initially. I believe it's like $10,000. But, if you have an emergency, a legal emergency, that you were not planning to spend $10,000 on. So this is an option. So they, as a pre-qualification, they go ahead and basically you submit your information. I think it's very basic information you got to submit. It will not be a hard credit pool. And they'll send you back, listen, you qualify for, say, $5,000. And these are the terms. If you choose that you want to pursue it, then you go further on whatever process they have. So that is one option that you have that is available to our clients if they choose to pursue it. The second one is quick fee financing, which is also, it's not credit-based in this one. This one, they allocate certain amount of quote-unquote credit, which they allow my law firm to offer to clients, and it could be something between $5,000 or $10,000. The interest rate is, I'm going to just give you an idea. Don't quote me on this, but they have it in their portal once you see the link. But I've seen interest rates in the 6% range that they offer. And this is not credit-based. It doesn't show up in your credit. It's simply another option that is available. We provide the link to the clients. If they're interested, they want to pursue it, to see the terms. The clients submit the application directly, and the process begins. But what it does, it creates a bridge. And the thing about litigation or lawsuits, they're time-based. When you receive a lawsuit, you have 20 days to reply. So in essence, you have 20 days to get an attorney. So you get a small extension, so you may have another 20 days. So you're looking at 40 days to decide how you're going to handle that lawsuit. And if it's something that you are compelled to get an attorney because of the type of lawsuit that it is, then you clearly need to find funds to pay this lawyer. So is there two options available? And at the very least, these financing companies offers that initial bridge that allows you to mitigate that emergency that you were not expecting at the time. So I just want to share those 2 points with you at the beginning of the podcast. I don't want to leave them at the end because they're very important. And if you have a takeaway here, and I'm going to talk more about the specific aspects of litigation that are why litigations are so expensive and what can you do about it. I want to give you those 2 points. So lastly, you know that if you're in a situation, you have a legal matter that requires, you don't know how you're going to get the funds, there are 2 options available that we can discuss. If you're interested, if you call us for potential representation, we can discuss that further at a later time. So why are lawsuits so expensive? The reason for that is the time and preparation. That's basically my opinion on that. The amount of time that it takes to really prepare for a lawsuit or prepare for any type of litigation, case, and also the expense that we have to go through, or the time that has to go through in getting this case ready for trial. And I'll give you a number of examples. So say you have a case, and I'm dealing with a number of them right now, and in business litigation, everything stems from a contract for the most part. It deals from an agreement that went wrong. So we begin to put the story together. Usually it's 2 parties that agree to do something. Sometimes they put it in writing, sometimes they don't. And we know that before. I recommend that all agreements be put in writing so that way you know what the terms are. And so one party feels that the other party breached the agreement. And the party feels that because of that breach, that party suffered damages. The plaintiff suffered damages. That's the classic breach of contract case. In most cases, most breach of contract cases, there's a lot of text messages, there's a lot of emails, there's a lot of documents involved. And in some cases, I have a case, a recent case that I was basically in discovery. They provided us over 3,000 documents that were a combination of emails, letters, text messages, pictures, so you name it. So when the attorney is given all this information, then there's time that will be required to prepare for this. to basically analyze these documents and then begin to see whether these documents match to the narrative to prove or disprove your case. So when I hear, that's just one example of that. And obviously there's software that we can utilize to streamline the process. There's things that we can do, and business litigation attorneys with good knowledge of technology, like we can streamline some of the process and analyzing those documents, but it's still preparation time because it is your story. We know the law, you know the facts. The facts come from you. And in commercial litigation and contract litigation, things are just not black and white. There's a lot of nuances. There's a lot of things that were said. There were a lot of things that were said by verbally, things were said by text, some things were sent by email. So you're trying to put a puzzle together, and I want you to imagine trying to put a puzzle together with missing pieces, or the pieces just don't fit. So it's not very clear. You're trying to create a timeline with various documents that just sometimes don't make any sense, at least not to you. And then you have to meet with the client and basically go through these documents, say, what does this mean? Or if there's a document that does not look very well for your case, you have to go back and say, hey, I did not remember seeing this document. What does this mean? What happened here? So part of our job is to understand your story from your perspective, but also understand the story from the defense's perspective, because that's where we're going to try to prove your case. So one of the things that we do is basically the time is, involved in the level of preparation and understanding your case. We have not even filed a lawsuit yet. We have not even filed any defensive pleadings yet. All we're basically doing is analyzing your case and understanding it to be able to begin to prepare the defense or the prosecution of your case. So a lot of time goes into organizing the documents. We go into, cataloging those documents. So think about it. If you're given 3,000 documents, how long will it take you to actually organize those documents? It will take you a long time. So it's not as clear cut, and also you have to analyze them as well to see if you can use them to prove or disprove your case. 80% of litigation at the beginning is motion practice. So when I say motion practice, you have the preparation of the lawsuit. That takes a few hours to do, depending on how many facts you have. And we go through a number of drafts in preparing that lawsuit. Because when we prepare the lawsuit, our job is to prepare in such a way that we'll survive an initial motion to dismiss. We have a good idea what the other side is going to do. We've done it before. We represent both plaintiffs and defense. So in crafting a lawsuit, it's an art and a science at the same time, because you have to be able to prepare it in such a way that meets the requirements of the Florida Rules of Civil Procedure or the federal rules as a federal lawsuit. And also you always have to basically draft it in such a way, thinking, okay, how is this going to be attacked by the defense? How is the defense going to poke holes on my lawsuit, and how I can overcome that? So we're thinking in both ways, thinking, yes, we're putting our story together, but also we're putting the story clearly so it can be easily read and understood, but also in such a way that when we file it with the court, it will survive, which inevitably most likely will be a motion to dismiss, because that's the first plan of attack when you have a lawsuit filed against you. We try to find for defects in the lawsuit, or technical defects, or a defect in law, and that's what we try to do first. So as I'm drafting my lawsuit, the first thing I do, okay, will this survive a motion to dismiss? And I keep refining it until I believe that is sufficient enough to send to the court, and have with the confidence that I know will be challenged, and the confidence to know that there's a very likelihood that that motion will be denied. So just to give you an idea, lawsuits don't automatically are prepared and from scratch, and the first draft goes out. No, it goes through a number of versions of it and make sure that it's done right. So that's why it's expensive. You're talking about an attorney's fee. You're talking average of $500 an hour. Clearly, we use paralegals as well to assist us. That'll streamline some of the process and also streamline some of the time that it takes. And obviously, we've done this before, so we use a number of templates to make sure that so we don't have to do everything right from the very beginning. But at the same time, we have to, the story is yours and it's unique, and the story has to be clearly outlined and presented in the lawsuit so anybody can read it and make sense of the lawsuit. So that's a good amount of time that takes preparation and also the drafting of that particular complaint. Say you're on the defense side, we go through the same process as well. You're the one being sued. We have to go ahead and look at the lawsuit and initially begin to think, how can we attack this lawsuit in a motion to dismiss? And, and I'm not going into a more detail in terms of the requirements for motion to dismiss, but just to give you kind of an overview, simply we cannot go outside of the four corners of the complaint. The lawsuit has to be defective into what it has been filed without any additional facts outside of the four corners. So we begin to look, okay, did they do this right? The elements of the claims are all pled. Are all the facts are clear? And we go through a series of analysis. The statute of limitation has ran. Is there anything, any defenses that we can raise here? Can we move to dismiss this complaint and why? So we go through an analysis, we look at case law, and then we decide, okay, we have two paths here when you get sued. We actually do, either we can file a motion to dismiss, if it makes sense, or we can go ahead and do the answers and affirmative defenses. So there's two paths that we have. By any chance, in some cases, the lawsuits are well pled, and we don't see any reason, a legitimate reason why to raise the motion to dismiss, simply because it hasn't well pled and very likely will be denied. And we don't want to create a situation that we're creating an unnecessary hearing, because that'll increase more expenses. So in that particular case, we go straight to the answers and affirmative defenses, answer the complaint, raise our defenses, and close the pleadings. So that's a decision that we have to make as well, and analyzing your case. And that also translates in time and preparation and analysis and drafting. So you see my theme here and why lawsuits are expensive, because the attorney has to spend time focusing on your case and making sure that everything is covered. And unfortunately, in litigation, because it is an adversarial process, you have a situation where the other side can actually create work for you. And it is not fair, but it's also utilized as a strategy. And I mentioned before that litigation is a battle of resources. You can have a great case, a winning case, but if the other side has more resources than you have, very likely you will not be able to survive that litigation, because you have motion practice, you have something called discovery. And let's talk about that for a second. Discovery, as I mentioned before, is written discovery, and there's also deposition discovery and actual live testimony discovery. We serve interrogatories, which are questions under oath that the other side has to answer. We limit it to 30 in the Florida rules. We can ask for more. Request for admissions. And the one that really takes the most time and is the most time-consuming and in some cases irritating, because the amount of time that it takes, is the request for production of documents. And there's no limit to how many documents you can request, provided that they're relevant and they're related to the lawsuit. And a good litigation attorney can come up with a list of 50 or 60 documents or types of documents that we can request in order to gather evidence for the case. But also, it really takes more time to the other side in preparing those documents. They also do the same thing with us. I've seen requests of 100 requests production. some of them repetitive. And basically when you do discovery, you do a broad scope discovery, and sometimes you're asking for the same information in different formats to make sure that you cover all your bases. So another item that takes a lot of time, and again, attorney's time, paralegal time, is responding to discovery and then reviewing the discovery. Because one thing is preparing it to send it out, but when you're getting back, you're getting thousands upon thousands of pages of documents. You're getting interrogatories, so sometimes they're not complete. In fact, very seldom when you receive discovery back from the other side, the discovery will be actually complete. It will be thorough. So you have to then go back to the attorney and say, I need your client to answer the following interrogatories, because they're not complete, and you begin this letter writing campaign with the attorney about, no, they answered it correctly, no, we did not answer correctly. And then, you have to basically, if you disagree with the attorney, then guess what? You have to go in front of the judge for a hearing on either objections to interrogatories or motion to compel. That translates to time, because you got to prepare a motion, you got to basically send it to the court, file it, then you got to discuss it with opposing counsel. We're required to have meet and confers with opposing counsel before a motion, before we actually set a hearing. It's a requirement now. And then we have to find a time or a date in the calendar with the judge to be able to have a 5 to 15-minute hearing. And a lot of times then we look at the judge's calendar. Many times they have times available, sometimes they don't. So we select this number of dates. The paralegal sends that to the paralegal of the other law firm. Then we begin to compare calendars. You get the idea how this is time consuming. Then we agree on a date. If everything works out well, the date is available, then we set up a notice of hearing. And then we get it noticed. We put it in the online calendar with the judge. We have to send courtesy copies with the judge online. And rare occasions, which happened this week, we are going to send hard copies of documents to the courthouse. But most of the time it's online, which is very convenient. Before we had to put binders together, and it was very time consuming and expensive to the client. And then we have our hearing. That's assuming that we actually agree on a date. In some cases, there might be 2 or 3 times of rounds of dates exchanges between law firms before they actually agree on a date. And in some cases, unfortunately, then the date is taken by another law firm because, at least in South Florida, in Broward and Miami-Dade, and probably Palm Beach case, the judges have maybe a few thousand cases that they're managing. And then you have a 20 days in the week, and you will have for motion calendar or small matters hearings, you might have an hour and a half each day. So that gives you an idea of why sometimes it takes time to actually get a hearing with the judge, simply because they have too many cases, you don't have enough time. And then this is all work that's done behind the scenes that you do not know about. So it takes an average about an hour of paralegal time to schedule a 5-minute hearing with the court, or a 50-minute hearing. And then for that hearing, then as attorneys, we got to prepare for that hearing. And then we have to go online. If it's between 8:30 or 8:45 to 9:30, if we don't know, we have to basically be there 8:45 online. Now it's via Zoom in most cases, but they have to wait our turn. So we have to basically sit there and wait until your case is called for your matter to be heard. So that translates to time, preparation, and unfortunately, very high legal expense. And again, we have not even talked about trying your case. We have not even talked about motions for summary judgment and depositions. And I want to talk about depositions a little bit more. And depositions are, questions that are under oath. This is all part of discovery. So you will be deposed as a party. You will be deposing the other side, whether it's plaintiff or defendant, but also you might have witnesses that you might call in for, that they have some information about the case that you have to depose them, whether it's live or through documents. So we do that through a subpoena. But in order for us to issue a subpoena of a non-party, we have to prepare what is called a notice of intent to issue a subpoena duces tecum, and then we have to, or notice of production of non-party, we got to submit the proposed subpoena to the court along with our notice, and the opposing side has 10 days to object. And if they do not object in 10 days, then you can issue a subpoena. If they object within the 10-day period, then you have to have yet another hearing with the judge in order for the judge to determine whether or not the subpoena can be issued or not. And then we go back to square one, as I mentioned before, and try and set hearings. So you have the idea of this is all happening behind the scenes, and in some cases, you as the client feel that, I just don't have control of the case, and it's taking too long. But this is kind of gives you a flavor of why it's taking so long. Because a lot of things are happening behind the scenes that you're not involved because you're not in control of the case. And the reality is when you're filing a lawsuit, the attorneys and the judges and the court system have control of the case. The only time that you have control of your case, in my opinion, is during a mediation conference. And I went over that in a prior episode. In a mediation conference, you decide whether it's going to get settled or not with the other side, with the other party. We are facilitators. We are providing assistance. But ultimately, we don't make that decision of whether or not you're going to settle your case. It is yours. So that's why I encourage my clients, and basically all my cases, I encourage mediation sooner rather than later to give the parties an opportunity to try to resolve the case at the time versus waiting a year later after you spend tens of thousands of dollars in legal fees to try to get it resolved. And I believe cases resolve sooner if the parties are given the opportunity and are given kind of a reality check, so to speak, as to the amount of money it's going to take a case to trial. And the versus basically waiting to 18 months or 10 months later to say, okay, let's try to resolve it now. At that point, the parties already have invested so much money, they're willing to roll the dice and see what happens at trial because they already spent the money and were getting ready in the first place. So another point that I wanted to make to you is that you have to, when you have a litigation case, you have to make a determination how much money you're going to spend on litigation. And it's not a very easy decision to make. It's money you were not planning to spend. How are you going to, and also it is something in some cases that you are compelled to spend because you're defending the case. If you're the one suing, you got to decide, okay, this is what I'm trying to get here. This is the damages that I have. These are the damages that I have. So you have to make a determination, is it worth it? And sometimes it's not an easy answer. In either way, it's not easy to make that decision, whether the one you were suing or the one you're being sued. Remember, if you're the one suing, it's important to have that analysis and that conversation with your attorney about realistically, if I take this case to trial, how much this will cost me? And the reality is not that simple. In some cases, a case could be a $25,000 case, but it's very document intensive. An example of that would be a construction defect case, or say a contractor that did some remodeling in your property and did not pull permits and then brought subcontractors and they did a bad job and then you have damage in your property. There are a lot of pictures that are taken there. There are experts that have to be hired. There's usually videos in these cases. So there's emails and text messages back and forth. So when you're dealing with that, a case like that, actually the legal fees can exceed the amount of the claim simply because the work that we have to do in terms of motion practice, discovery, depositions, expert witnesses, does not change whether it's a $25,000 dispute or $1 million dispute. It's exactly the same work. It's not fair, but it's the same work. So we cannot basically adjust our fees based on the amount of the dispute because the work is exactly the same. There's no way to streamline the work. The work has to be properly prepared, has to be competent, has to be quality. And then, that decision has to be made. Do I settle for this amount and avoid all the legal fees? Do I sue, knowing very likely that I'm going to be sued back? That's usually a strategy as well to an defensive posture, that they sue you back. Do you have a counterclaim? Why? Because they do it just to force you to spend money. And once you get into litigation, it's really difficult to control it, barring the parties deciding they don't want to continue, which sometimes it happens, or if the parties decide, settle for a lesser amount to basically end the financial bleeding that goes with litigation. So, why losses are expensive? It's preparation and time. And also a third reason is because the opposing party will create work for your attorney in the form of depositions, in the form of hearings, in the form of discovery. It's an adversarial system, so both parties are basically sending motions back and forth, and sometimes it's a war of attrition. So even if you have a great case, does not mean that your case will prevail. There's really no slam dunk here. There's no, especially in business litigation, it's about the facts and how the facts are applied to your case and the ability of your attorney to present those facts and utilize the tools available to win your case. So it's a lot of factors here, a lot of moving parts, so to speak. So I want to leave you with that. I'll basically share with you, the answer why losses are expensive. And if you're in a situation that you have in the middle of litigation, you want to discuss this with us, my website is floridasmallbusinesslegalcenter.com. My email, again, is rich@richsierra.com. If you want to give us a call, number is 866-842-5202. Something that I do not recommend is for you to defend or initiate a lawsuit by yourself without discussing it with an attorney. That's very important because that conversation can save you tens of thousands of dollars. This is all for today. I appreciate you listening to me today. Again, we're on Instagram at FSB Legal. If you like the podcast, please give us a 5-star review. Share it with your friends. We also have the video on our YouTube channel, youtube.com/@RichardSierra. Until next week, remember that my goal is to help you succeed.